Hello, my name's Tom Cook. I'm a barrister here at Church's Solicitors. So one of the most nerve-wracking things that anyone can do in a court is give evidence. And that is the same whether the case has been brought against you, so if you've been charged with an offence, or if you're just attending as a witness to either assist the prosecution or the defence. If the lawyers who are asking you questions are any good, you'll be pretty exhausted by the end of it. So these are a few guidelines that I give to everyone who is involved in any case that I deal with and has to give evidence. First of all, what you need to do is just remind yourself that all you're doing is answering questions and telling the truth. It's a bit like when someone's stepping up to take a penalty in a football match, and if they can just not let the occasion get to them, it's as simple as putting the ball in the back of the net. The difficulty is the pressure, the occasion, etc. So just remind yourself that all you're doing is answering questions and telling the truth. And here are a couple of guidelines to help you. The first is, if you don't know the answer to a question that you are asked, then the right answer is, I don't know. Don't try to be helpful. I've seen many times people try to be helpful and then they end up being wrong because they didn't know, and they end up with egg on their face, and then they get a bit nervy, and of course it can also affect the rest of their evidence and perhaps affect their credibility in the eyes of the court. So if you don't know, then you don't know. Similarly, if you can't remember the answer, then the right answer is, I can't remember. Quite a lot of the time, the court has listed trials 2, maybe 3 years after an event has taken place, and you can be forgiven for not remembering exactly how something took place. So if you don't know, you don't know. And if you can't remember, you can't remember. Now, the way in which most cases work, and certainly in criminal cases it works this way, is that the first person to ask you questions will be your lawyer. It could be your solicitor, it could be your barrister, it could be your legal executive. So they're going to ask you questions, and they have to ask you open questions. So that's sort of who, what, why, when, where type of questions. The idea of that is to allow you to tell your own story. The rules are slightly different in things like civil and family proceedings, because this evidence, which is called your evidence in chief, will have been produced in a statement. So your lawyer in those circumstances will just be asking you a couple of supplementary questions, a couple of questions to kind of clear up anything that's unclear in your witness statement. In crime, however, what they're doing is getting you to tell your version of events, and they're not allowed to lead you, they're not allowed to tell you what happened. That's your job, to tell the court what happened. But it's a bit different when the second person stands up, so that's going to be the prosecutor if you're a defendant. Because what they have to do is to put their case to you. And that may very well involve putting you under a bit of pressure. That will involve saying that what you have just told the court is perhaps not right. You could be mistaken, you might be lying. All of those things might be suggested to you. So here's a very important guideline for you to follow. When they are asking you questions, so that's when the other lawyer, not your lawyer, is asking you questions. If you disagree with what's put to you, you are entitled to say that you disagree, and really importantly, you are entitled to say why you disagree with it. We've all seen many dramatisations of evidence given on TV programmes, films, etc. And you'll note how the prosecuting lawyer manages to box someone into a corner. That's their job. Their job is to put their case and to show that your version of events is wrong. But if all you're doing is answering questions and telling the truth, in order to avoid getting into a corner and feeling that you're squirming or uncomfortable, just say that what they have said to you is not right, and then say why it is not right. Because that way, you're in control of your evidence, and it is your evidence, and the court is interested in what you have to say so that it can come to a conclusion. So those are my guidelines on giving evidence.